Hello, everyone. So let me tell you how we're going to proceed today. Because several of the participants in the prior sessions specifically asked for us to talk a little bit about organ donation and cremation, we're going to spend a few minutes on that subject, no more than 10. Rabbi Syme and Rabbi Miller will speak about the religious aspects of that. I'll talk about the legal aspects of that. And then we're going to move right into a discussion about dispute resolution, what sorts of disputes arise at the end of life, and how to resolve them. And then, as Rabbi Miller indicated, at the end, we're going to leave some time, separate from your opportunity to ask questions now about what you hear today. At the end, we're going to let you ask questions about anything you want, anything to deal with end-of-life decision-making, whether we've covered it or not. So with that, I would invite Rabbi Syme to come up and talk about the Jewish view of cremation.
Cremation is absolutely forbidden. It prevents you, theoretically, from achieving resurrection. Temple Bethel's cemetery is the only cemetery in the Detroit metropolitan area that allows cremains to be buried in the consecrated part of the cemetery. In other words, if a husband and wife wish to be buried together and one of them has a regular funeral and one is cremated, Bethel is the only cemetery where they can be buried together. In other cemeteries, to the credit of the conservative movement, they have recognized the rather widespread growth of cremation, and there is a separate section, Clover Hill and Machpelah, for the burial of cremains. Now, the problem arises when you deal with the Holocaust. And this was a great debate within Orthodoxy. 6 million people burned. Will they enter the world to come? Yes. Thank you, Margie. Margie knew immediately, probably because she read my book, What Happens After I Die. I'm not going to ask any of you. I'm not that kind of author. I'm not going to ask you to read my book. I just would like you to buy it. And whether you read it or not is entirely up to you. So the rabbis ruled that the victims of the Holocaust were kadoshim, holy ones, and therefore God would see to their entering eternal life. There is no branch of Judaism that encourages cremation, but I speak personally today, and I have always believed that any means that brings comfort to a family at a time of loss is, for me, accepted and permitted.
Jewish tradition has always considered the Jewish body to be a gift from God that really houses our soul and is a temporary thing. We don't own our bodies, so we don't have the right Jewishly to make any decision we want about them. There's a sense of respect that goes into it. And I think, as Rabbi Syme said, and as I agree 100%, we also have the ability to decide how we respect those bodies and how we take care of them, including at the very end, which is why Bethel has made the decision it has made, and Reform synagogues around the country similarly have made those kind of decisions. It really is the same thing when it comes to the question of organ donation, with an extra twist. The same part is that Jewish tradition would also tell us that since the body does not belong to us, we can't just do whatever we want with it. However, two things are important for this discussion. The first one is that just like we respect our bodies, we respect other people's bodies, meaning that if we have a part that's going to help someone else, it's entirely a sign of respect, and it's a good use of our bodies to help someone else. It might be our corneas, it might be a liver, it might be lots of things, but the truth is we show respect for creation and for God by helping other people, not only ourselves. And of course, the even greater concern, and this is the one that Orthodox, conservative, and Reform rabbis and scholars around the world all agree on, and this is one of the areas, maybe I would say one of the few areas, that there is almost universal agreement on, which is that organ donation is encouraged because of saving a life. One of the highest values in Judaism, of course, is saving, protecting life. And so if you have an opportunity to do that, the value of saving a life outweighs the value of sort of protecting and respecting our physical bodies. So again, there are huge Orthodox responses on this. There are Orthodox organ donation organizations. So this is not one of those things that here at Temple Bethel we're telling you one thing and you go down the street and hear something else. Around the world, generally speaking, everybody agrees that organ donation is not only acceptable but encouraged because it goes a long way towards saving a life. So that is sort of the simple answer, and in this case, there isn't a lot more to it. So before we move on to Andy, does anyone have any questions about either the question of cremation or organ donation before we move on beyond that? So the question was, in the case of cremation, can you spread the ashes anywhere, or do they need to be buried in a specific place? So what Rabbi Sai mentioned about our cemetery, which is the only one that allows those cremains to be buried in sanctified grounds, what that means is that a lot of places, if someone chooses to be cremated, then they don't have any choice but to bring those ashes somewhere else. Maybe spreading them, maybe holding on to them, maybe burying them in their backyard. People make different choices, but it is an option, and I think the statement that Temple Bethel is making is that this is a choice that is not only one you can make, but that is accepted and sanctified by the temple and by Jewish tradition. So that's the idea of burying them, sort of raises it to a higher level when it's in the cemetery, but people make other choices in terms of what they might do with those cremains. So I'll ask Andy to come up, and this will transition into what he's talking about, because part of the question was, is there a legal reality to if there's a difference of opinion about people wanting to be cremated? So I'll ask Andy to come up to respond to that. As he does, I'll just tell you that Jewishly, it's a difficult issue, and this is one of those areas that there isn't a simple answer, and there are really two responses. The first one is that, like everything else, the goal is to help families come together to make decisions that are comfortable for everyone. So even when people disagree, which happens all the time, right? We disagree about all kinds of things, big things, small things, but our goal as a temple, as rabbis, is to help people find common ground, right? Even when there's a disagreement. The second answer that I think helps sometimes is that when it comes to something like an issue of cremation, what we try to do is help the family find traditional responses to answering the question. So sometimes people come in with just their raw feelings. I want to do this, I want to do this. And it's very hard to bridge that. But sometimes when we can show someone a text or a Jewish argument or a story, something like that, that gives other examples of how others have done this, people can find a way to connect to that. So maybe, one person absolutely wanted to cremate, the other one absolutely wanted to bury, but maybe it turns out that it's the connection to the ground that's most important. So getting back to the earlier question, maybe they could end up agreeing, we're going to cremate our loved one, but then bury them in the cemetery, which gives that connection. So that's not a simple answer, but my point is we're looking for common ground.
Let me answer your question. Michigan really has one of the strangest statutes there could be concerning cremation and who has the right to make the decision. In fact, in Michigan, if I wanted to be cremated on my death, I could write that down. I could put it in my will. I could put it in a document other than my will, but it wouldn't necessarily be legally enforceable. The statute in Michigan says that the decision what to do after death regarding cremation is up to the surviving spouse. And if there is no surviving spouse, then it's up to a majority of those next in line, typically children. So if there was no surviving spouse and there were 7 children, a funeral home would have to go out and get the consent of 4 of the children for a cremation, regardless of what I had indicated, I wanted in my document. That really doesn't make any sense, and it's very controversial. In Michigan, funeral home directors are trying to get it changed. Lots of other thinking people are trying to get it changed, but that's where we stand right now. Now, there's one other wrinkle here. For those of you who were at the last session, you may recall that I mentioned that just as of the time of the last session, I had been involved in a family issue concerning organ donation to the University of Michigan Medical School. We have a different statute in Michigan that says that if I want to donate my body for research purposes, I can sign a form now, and you can put that on your driver's license. You can do that. You can put that in your will. You can put it in any form, and you give it to 2 adults, one of whom has to be a disinterested person, so you could give it to your spouse and your attorney or somebody else. That would be enforceable. And what the medical school does, University of Michigan Medical School, for example, is that once they have completed what they needed to do with the body for purposes of research, they will then do a cremation, and they will return the cremated remains within 18 months. Now, I honestly can't tell you what would happen if I filled out one of those forms and everything went as I had hoped it would, if that's what I wanted to do, but after my death, one of my kids or my spouse said, no, we don't want to go forward with that, because I think under the statute, using the statute that permits you to fill out the form for while you are alive, to elect for an organ donation followed by cremation, that would probably be binding. If a court got involved in a family dispute over that issue, I would hope a court would look at my wishes and would say, it's clear what Andy Broder wanted, we're going to permit it. Don't know for sure, but that's my best guess. Other folks have the right to make decisions concerning organ donation. My patient advocate, for example, if I were in the last stages of life and I had a patient advocate acting for me, my patient advocate could fill out one of those forms and could decide to donate my body to medical school for research. The statutes here, and by the way, this is in your handout, and I've identified the statutes. We've talked briefly about who can act for the patient. While I'm alive, I can act for myself, with the caveat that if after my death a family member disagrees with a cremation decision, I can't say with absolute certainty that my wishes would be honored. I hope they would. While alive, the patient or patient advocate can make a decision. Keep in mind that a patient advocate's authority terminates the moment the patient dies. So the patient advocate has no authority after the death of the patient. It's the surviving spouse or the majority of the next of kin. One other comment, then we have to move on with the other issues here. For important things, for important instructions like this, or where you want to be buried, don't just put that in a will. A will may not be looked at for several days after you've died. You can put it in a will, but make sure that your wishes are also known to people and maybe written down somewhere else. As far as I'm concerned, for now, we're done with the cremation and organ donation subject, and we're going to move into the other principal issue for today, which is resolving disputes that arise. You've heard throughout our sessions that statements in an advance directive, discussions with family members, discussions with your doctors are important to help avoid disputes at the end of life. Some interesting statistics here I thought you'd like to see. 90% of people, and these are about a year old. You know, it takes some time for people to submit the survey and then they're published. So about a year ago, a national group, a very well-respected group, published these statistics that 90% of people say that they want to talk with loved ones. It's important to talk about end-of-life issues, but only 27% have. 80% of people say that it would be important to talk to their doctor in advance of a crisis, and 7% reported that they had done so. I mean, that's a staggeringly low number. And 82% of people say it's important to put their wishes in writing, and 23% have done so. I suspect the number's higher now. I mean, that one I have a little problem with. But the point, nevertheless, is that there is a gross disparity between the number of people who express the need to articulate their wishes and who actually do so before there's a crisis and perhaps they're unable to speak for themselves. Now let's talk about the kinds of disputes that arise at the end of life, at the bedside. There are a variety of circumstances that give rise to these disputes. The first one, insufficient time to consider important decisions. That happens a lot, as you might expect. Somebody has a heart attack or a stroke or some other critical event occurs, a car accident, and they go to the emergency room and they're not in a position to express their wishes. And family accompany them and the doctors come and say, you know, here are the choices, you can do this or that. Well, there's not a lot of time at that point for family members to consider what to do. And the fact that family members have to make decisions like that on the spur of the moment, in a crisis situation, laden with emotion, is really an awful time to expect that they can really state what they want for their family members, particularly if the family members haven't expressed themselves, if there's no advance directive. They need time. Now, we talked at the last session briefly about the fact that it used to be thought that if someone showed up at a hospital and were put on a ventilator or other machinery, that could not then be removed. So family members thought that they had to make a critical decision that was irrevocable. That's not true. I would certainly submit that if there's any doubt as to the patient's condition and prognosis, one ought to err on the side of providing support, life support, and then once a determination is made as to the patient's condition and prognosis, then you are in a position to make a much more sensible and informed decision. What you decide at the beginning is not irrevocable. I've had some clients come to me and ask me to get involved in end-of-life decision-making issues where the event occurred the day before. And I say it's too early to make a decision. Unless you know exactly what that patient wanted, you need to find out. Give the doctors an opportunity to find out what's going on with the patient, what's the patient's prognosis, and then decide in the future. The next bullet point there is has to do with healthcare staff may not understand the beliefs and feelings of the patient and family. Especially if you go to a hospital, you're going to be assigned to the attending physician who might not have the slightest idea, likely will not have the slightest idea what your wishes are and what the patient's wishes are. If they're not in writing, if there's no advance directive, they're going to err on the side of wanting to treat, as well they should. So it takes time to have that dialogue between family and treating physicians. Families, patients who are in a position to listen to an explanation of their condition, may simply be unwilling or unable to listen or to respond at the beginning. If they show up in a critical situation at the hospital, again, because of time considerations and the emotional component that is actively being developed there, the family may be resisting what the doctors tell them. All of this, it all comes back to time, and it all comes back to communication. There are often pre-existing family disputes concerning financial matters and cultural and ethnic and religious matters. There's one decision that I found very interesting. A few years ago at Detroit Receiving Hospital, a family was asked to make a withdrawal of life support decision for their loved one, and while they were pondering that decision, the patient actually ceased all brain function, was brain dead. And they said, our religion requires us to ask you to keep the patient connected to life support. We need more time. We need to meet with our clergy members. So as a matter of our religious practice, please do not disconnect life support. Well, we have a statute in Michigan, the brain death statute, that says that if there is irreversible cessation of all brain activity or respiratory or circulatory function, the patient is to be pronounced brain dead and no more life support should be provided. The hospital withdrew life support because the patient was brain dead, and then the family sued. That case went to the Michigan Court of Appeals, and the family lost. The court said, our statute's clear, this patient was brain dead, and therefore there was no other decision to be made. Now, we've talked a lot about persistent vegetative state. You know, we talked about the Rosebush case, the Cruzan case, the Quinlan case. These are all patients who, in a persistent vegetative state, couldn't really do anything for themselves, but their lower brain stem had some function, so they really weren't brain dead. The point is, if somebody uses the term brain dead, that's a term of art. It's a medical term. That's a statutory term that requires termination of all treatment, no decision to be made. There's this case that has been pending. First it was in California, and now New Jersey, involving what's her name, J.V. McGrath, something like that. The 13-year-old who had some minor procedure and ended up, according to the doctors, becoming brain dead. And she was to be withdrawn from life support, and their family found a doctor who said, she's not really brain dead. There's some minimal function, keep her alive. And they've been fighting that out in the courts in California and New Jersey for the last 10 months. Family members may be frustrated by the healthcare system, by cost of care, and by their patient's illness. I mean, they want their family member to respond. They're guilty, they're angry, they want the doctors to do something to help the family member. So that causes a difficult communication when healthcare providers are trying to work with family members to reach a sensible decision. Cost issues are horrendous, getting worse. Family members, on the one hand, want to provide everything they can for their loved one. On the other hand, they're concerned about the cost of doing so, so that makes you guilty right from the start. I wouldn't want to be maintained in a persistent vegetative state, not only because of the emotional turmoil it would wreak on my family, but the financial devastation as well. And that's why I have a document. And I think if it's important to you, you ought to have one too. Family members and healthcare providers can't magically resolve issues such as cost of care. That's just a reality that we're all going to have to live with or not, as the case may be. But it's certainly a component that needs to be openly talked about and not simply swept under the rug. Treatment may be fragmented and impersonal, especially at hospitals. We have doctors and nurses coming in all the time, different shifts. It's hard to develop a bond with healthcare providers under those circumstances. And yet, when you're trying to make important decisions at the end of life, you need to have a bond and a trusting relationship. So you have to go out of your way to express that frustration openly to healthcare providers and try to fashion a way to be able to communicate better. And the final bullet point I have here is an honest disagreement as to what is meant about futility of treatment. You know, you hear the phrase futility, it's futile to treat the patient. Well, at the end of life, that term is very difficult to apply. In the dictionary, futility means incapable of producing any useful result or pointless. But how does that apply to a patient who has terminal cancer or is in a persistent vegetative state? Well, certainly, we'd all probably admit that giving penicillin to a cancer patient is futile. That's not going to cure the patient. But if a patient is in a persistent vegetative state and the issue is whether or not to put the patient on a ventilator or to continue ventilator support, I mean, there's no denying the fact that being on a ventilator may keep the patient alive. But what's the goal? Is the goal to keep the patient alive regardless of the condition? Or is the goal to restore some mental functioning to that patient? If that's the goal, being on a ventilator isn't going to do any good. Do I mean a physician when I refer to healthcare providers? Usually yes, but I mean if there might be there may be a nurse that you can talk to about the situation. There may be hospital administrators you can go to. Hospitals have patient care ombudsmen you can talk to about issues like this too, social workers as well. The point is, you don't have to sit in a hospital and simply take what's thrown at you as if you have no say in it. You can, in a nice way, make it clear that you have concerns about the course of treatment and you need to talk to the appropriate people. I mean, usually that ought to be the attending physician. The proposition here is that in modern hospital care, there are hospitalists. There are doctors who work for the hospital. They're employees of the hospital. They treat, tens and 20 and 100 patients a day, and it's a revolving door for them. But you may have an attending physician who doesn't come to the hospital at all. So you're in the care of these hospital physicians, and what do you do when they don't know you and the person who really knows you is the attending physician who isn't there at all? That is a disconnect. There's no question about that. I'll get to you in 1 second. And it's a problem. But in Michigan, for example, we have a statute, the Death with Dignity Act, that tells physicians who are treating patients at the end of life that they have an obligation to talk about all of the options, palliative care, medication, et cetera, and for my money, if I were in a critical situation, I'd rather be treated by a doctor outside of a hospital setting, not in a hospital. Now, again, I recognize that we can't always control that situation, but it is a fact of life. Patients who end up in hospitals because everything's fragmented, because you're not going to see the same people day in and day out, and you don't have much of a relationship with them, it's a much more difficult proposition to achieve what you want, which is, a sound and sensible delivery of appropriate care at the end of life. The question is whether it's sufficient to have your advance directive on file at the hospital. Is it helpful? Yes. Is it totally sufficient? No. A document expressing your wishes it certainly ought to be on file at the hospital. As a matter of fact, it's federal law now that if you go to the hospital, they have to ask you, do you have an advance directive? And as we talked about last session, in order for a patient advocate to act under an advance directive, it has to be made part of the medical chart. So it needs to be part of the hospital's records. And I can tell you from personal experience that Beaumont Hospital pays attention to those documents. A couple of years ago, I had a client who was ultimately had a stroke and died at Beaumont Hospital, and he had been there for 10 days or so, and his family had given the hospital the advance directive that I had prepared. And well after the funeral, the family called me and said that the chief of emergency services there had told them that that was the best advance directive they had ever seen, and they wanted it on their teaching service. Would that be okay? And so the family asked me, and I said, sure. So they pay attention to those things. So let's keep moving. The notion that courts are the only arbiter of disputes at the end of life is wrong. In Michigan, the Rosebush case, which was a case that I had several years ago and we've talked about a couple of times, the Court of Appeals indicated right in that case that it's the policy in Michigan for courts not to delve into the whole decision-making process at the end of life. We hold the general judicial involvement in the decision to withhold or withdraw life-sustaining treatment need occur only when the parties disagree about treatment or other appropriate reasons are established for the court's involvement. But as a matter of public policy, the court has said, don't bring these disputes to court. They don't belong in court. Now, certainly the courts do get involved in decisions where it's unclear whether the patient has decision-making capacity, whether the patient's treatment decisions are valid, whether an advance directive is valid, whether a patient advocate is acting properly, those sorts of things right in that patient advocacy statute that we talked about last time indicate that if there are disputes, you can go to the probate court on an expedited basis to get them resolved. So you have the Court of Appeals saying, as a general proposition, don't come to court. You needn't come to court with these sorts of disputes, but clearly there are some disputes that are going to end up in court. How do we avoid going to court? If we've worked with doctors and the other healthcare providers and the social workers and the administrators, well, I submit to you that one avenue is an ethics committee. We use that in the Rosebush case. We use that in the Martin case. This is a group of individuals who typically are appointed by a hospital to help healthcare providers, patients, and families address disputes as they arise. The group of members of the committee would typically be physicians, clergy, social workers, a lawyer or two, lay individuals, a wide array of disciplines and philosophies, and their job is uniquely one to try to help families and the institution resolve disputes as they arise. The question is, would the representation of clergy in an ethics committee be diverse? Certainly it would. When disputes arise, an ethics committee is a wonderful resource to try to help resolve the dispute. The last place you want to go to is court. Family members should have the right to participate. Lawyers can if you want. If a family member wants to bring somebody else who isn't a lawyer, the ethics committee ought to be asked that and certainly ought to agree. When I've consulted to hospitals on this issue, I've said anybody they want to bring is fine with me, as long as everybody proceeds in good faith and there's some decorum to what's going on. Let the family be heard. Let's have a full airing of the concerns so we can try to have a sensible consensus reached. And ultimately, we certainly want to find out whether the committee is going to make a recommendation or a decision or is simply there to mediate. And I know of very few ethics committees that actually make any kind of binding decision. We've been doing this for an hour. It seems to me that, as Rabbi Miller indicated before, I'd like to give everybody an opportunity to ask any questions they may have about anything. As before, I'll try to answer directly and honestly without a bunch of legalese. And I know Rabbi Miller also has an announcement he wants to make. The question is whether, if a patient is in a hospital and is being treated by a so-called hospitalist, that is, a doctor on staff at the hospital, can your attending physician still interact with you and with what's going on at the hospital? Well, typically, yes. Some hospitals are a little bit weird about that, I must say. But if I had to be hospitalized, I know the internist I go to knows precisely how I feel about what treatment I want and don't want, and I wouldn't go to a hospital where he didn't have privileges and he wasn't going to be there to speak up for me. I wouldn't do that. Obviously, sometimes situations arise where you can't control that. If I'm in a car accident and I'm taken to St. Joe's in Pontiac rather than Beaumont, and if my doctor doesn't have privileges at St. Joe's, it becomes a more difficult proposition. But that's why I have an advance directive that's clear. The question, and it's a great one, is whether as a lawyer, I could have any input into essentially creating a registry for advance directives so that if something happened to me and if my wife and kids weren't available, doctors would know where to go to find my advance directive, because I might not have it in my pocket at the time I'm...
You don't know which hospital.
Right. So there is no registry per se. I think it's a great idea, and I think that we all should try to create that. It's not a role that simply should be reserved for lawyers.
Well, I think you should suggest it and put your name on it.
Okay, all right. The proposition is I should suggest it and put my name on it. I'm willing to do that. I don't know what will happen. But the question also implicit in that is what to do with your advance directive. Make sure family members have it. Make sure your doctor has it. Make sure you have it in your glove compartment. As we talked about one other time, emergency techs often go to, if they're coming to the house and you're the only one there and you're on the floor, they'll probably look in your freezer for an advance directive. I'm not sure exactly how that practice evolved, but many people keep a copy in their freezer. The question is, if someone has something informal attached to their will, such as a notation that my granddaughter wants this picture, is that binding? Well, if your will or your trust specifically says this sort of thing, which I always put in wills and trusts I do for clients, it would be binding. I put in a provision that says something to the effect, if at the time of my death there are personal notations among my possessions indicating to whom I want certain things to go, I ask that my personal representative or trustee honor them. So,
Is that necessary?
is it necessary? Well, I don't know how to answer that. I mean, I would hope that your personal representative or trustee would honor that notation of yours to give this picture to my granddaughter, even if you didn't have that sort of provision. But I would suggest that you put it in anyway. And you know, that applies to things beyond pictures. It can apply to jewelry or artwork or all sorts of personal possessions. Because typically, you know, wills and trusts will say, I give everything to my kids, you know, as they may agree. But again, I will put in, but if to the extent I have any special instructions that I might write out prior to my death, please honor them. The question is, what about the bullet point and one of the slides that a court might determine whether a patient's treatment decisions are valid? That would only be a narrow situation such as I want to be, remain connected to life support even if I am brain dead. So something that was clearly illegal or a physician deemed totally medically inappropriate. Not a legitimate health care decision. A court isn't going to get into that. But you know, sometimes there could be a patient or a family member making a request or a demand that is really outside the bounds, and that's when a court could step in. The question is, how does one plan appropriately, and what does one do with an advance directive? If you're in a situation where, in the event of an illness or an injury, you could be taken to any one of 4 or 5 hospitals, and your own doctor may not have privileges at all of them, or any of them, I should say. What do you do? It's a very difficult situation. I mean, if your doctor has, if your attending physician, if your personal physician has that advance directive, I guess I would suggest to you that if you were taken to Henry Ford and that doctor knew you were at Henry Ford and he had the advance directive, or she did, that doctor would, if a family member didn't make it available to the hospital, that the doctor would say, I know that the patient here has an advance directive. There isn't a perfect solution to this. You need to have it at home. You need to have it in some likely places where somebody might find it. Again, the premise is something happens to you and there is no family member who's going to speak to you, who's going to produce the advance directive, and how do you make it clear that you have it? I mean, it's a difficult proposition, but you have to have it with you or as close to you as possible, and hope for the best at that point.